What's up, everyone? Welcome to the channel. Let's talk about it. And in this video, I want to talk about my personal experience dealing with the Divisional Court division in the Superior Court of Canada. The Divisional Court is filing an appeal, if, especially for in my situation with a tribunal, the Landlord Tenant Board. I'm doing this video. I'm going to be honest. I got nothing to benefit, to mislead, or to bash anyone. I'm going to try to minimize the criticizing. Again, this is all going to be factual. There's some very disturbing events that took place in this appeal. There's some things that judges have done, and there's some things that judges let slide that normally shouldn't be or wouldn't have happened. I think in this situation with the appeal, it wasn't a good experience. Overall, it was not a good experience. There's things that happened that I did not anticipate. And to be honest, I think because I came so prepared and I took the time to get familiar with a lot of these things, my experience is that if I were to guess, that some of these judges just didn't like me. They didn't like that I came so prepared. And that, it's almost like at times I was looked at and it's almost like, who does this guy think he is? He's not a lawyer, and he's coming up here and he's self-representing himself. So there was just so many things that came from this appeal that was just, it's just mind-boggling. This is going to be a monster video. I'm going to go into details about from the beginning, filing the appeal, right up into the appeal. And I hope this video is helpful to anyone that is thinking about starting an appeal or that is going through the appeal. I'm just going to get into it. So thank you guys for watching. If you guys like these videos, then if you could please like and subscribe, and I'm always open to any type of comment, positive or negative. I'm just trying to share my experience truthfully, and it's not a good experience. So with that being said, I was illegally evicted from a basement rental unit by the hands of a lawyer, John David Ekpenyong. And he's also the lawyer that was handling this case. Just to be clear, no lawyer ever has the right to instruct his client to evict somebody. There is a tribunal, the Landlord Tenant Board, and you want to go through that process, you can go through that process. In fact, there was a eviction application before the Landlord Tenant Board that was withheld and hidden throughout for 2 years. So as there's this illegal eviction process going on, and I just want to say that I was trying to leave this residence. I was asked to leave in February. I was given 60 days. March 29th, 2022, I get an email from John David Ekpenyong acting like he's an actor, some superhero, saying he's instructed as a client to evict me. And that was inhumane. And it was in harsh conditions. It was at the peak of COVID, and it was in winter. 3 animals died from this eviction. 3 fish, exotic tropical fish. Well over $5,000 of my property got damaged. It was a straight up illegal eviction, and it was very unnecessary. I had to hire a paralegal. It cost me $3,000. I had to hire a moving company to help me move things from up on the hill down back downstairs. And mind you, this illegal eviction, the Waterloo Regional Police got involved, and they came to the residence that day. There was 3 or 4 officers. A sergeant came out, and they deemed, after their thorough investigation, that this was not a family matter, this was not a criminal matter. In fact, this was a civil matter. And in the presence of the Waterloo Police, in the presence of the sergeant, they allowed me to kick in the door. I was locked out, lock changed. They I'm trying to, I'm trying to move out. You guys can see in a previous video the details about the Landlord Tenant Board and the living arrangements. Don't need to go into any more detail about that, but I kicked in the door. I didn't get charged. It's the winter time, and got 3 fish out in the freezing cold. And again, this is all under the direction of John David Ekpenyong, who, mind you, has a complaint in the Law Society that's been sitting there for 3 years, and they refuse to do anything. Just like a side note, when you deal with the Law Society, file a complaint against a lawyer, and from my own experience, anyone that's thinking about doing it, don't even bother wasting your time. You have lawyers handling complaints against lawyers, where in the Law Society, whom lawyers fund. Don't even waste your time filing a complaint against a lawyer. It's just a biased complaint process. So back into this appeal, a little bit of background information. I get my appeal started with the Divisional Court. I file it in Toronto. In June of 2023, and don't mind me, because like I said, this has been 2 years of my life, and I wrote down every event, so I will be reading from a notepad that I have, sharing the facts of this. So here we go. Filing my appeal with the Divisional Court. If you guys are thinking about doing that, and what I had to do was, you have to file, and I have filed a Form 37A, which is a notice of motion for leave to appeal. And you file that within 15 days of the decision being appealed. Starting the appeal, you serve and file a copy of the notice of appeal to the Divisional Court, which is Form 61A.1. You also have to file the appellant certificate and respecting evidence, which is Form 61C. Transcripts to be ordered, and obtain a certificate obtaining a transcript. I ordered 3 transcripts referencing 3 witnesses who confirmed the living arrangements, confirmed that it was a rental unit. You can see in the other video of all the details. It was a rental property. There was a tenant there previously, which John David Ekpenyong and his client denied. Again, the other video can Landlord Tenant Board. There's all the details. So in order to get the appeal started, right, you got to order the transcripts from the hearing, and then you get into perfecting the appeal, which are specific and detailed documents. And they include the appeal book, the compendium, the exhibit book, appellant's factum, which is 5 parts and is certified. You order the transcripts. You prepare a book of authorities, which is cited cases from the Divisional Court. And you get a certificate of, completion. And you have 60 days to file your appeal with transcripts, and you have 30 days to file them without. So let's get into that. So I filed all that, and that wasn't easy. If you guys see my materials, I would have never done that had I anticipated what I'm about to share with you guys and how these judges handled this case. And like every matter I've dealt with John David Ekpenyong and eventually the Kitchener Court, it's just been nothing but a handicap match. So my appeal is filed on July 4th, 2023. John David Ekpenyong files his factum and certificate of service on October 23rd, 2023. A general rule is that there's 60 days allowed to respond, not a day more, unless you get the okay from a judge. That never happened. They never got the approval. John David Ekpenyong took 120 days to file his materials. That's prejudice right there, allowing that. On November 22nd, 2023, a case conference was held in Hamilton with Justice Sheard. Little background on this info from the OttawaMenCenter.com. It writes like general background info about this judge. I guess it was sourced from Canada.ca, and then it goes into a section called Reality Check. And the Reality Check, I'm just going to read it. What this website said. So yes. There's right. You got the first part, welcoming the Honorable Elizabeth C. Sheard, becoming a supernumerary judge as of April 3rd, 2023. Then it gets into their own literature that they've added, and it seems to be accurate with my dealings with her. But what this OttawaMenCenter.com states is it says Reality Check. Elizabeth Sheard spent most of her career working for Law Pro, the legal liability insurance for Law Society, who do nothing but protect lawyers from complaints with unlimited funds. In her world, money grows on law pro trees, and anyone who does not earn that kind of income is trash. She is guaranteed of supporting local lawyers and authorities who engage in criminal conduct. She was appointed because she received the approval of the Feminist Lobby Brigade, and in Ottawa, it is becoming increasingly impossible for a judge to appointed without being sure bet for enforcing Ontario's fascist program of female gender superior. Not even going to say it. Superiority. That means that any criminal or family court matter will be decided by her favor of the Crown or local authorities or a female if it involves gender, which it did. So, at times, dealing with this judge, she was rough and she criticized me of my materials without reviewing them. When asked about where the landlord-tenant hearings were heard, John David Ekpenyong straight up lied to this judge, and he told her that it was in Kitchener, knowing we had 3 hearings filed and heard in Toronto. Right, so this is one of many lies John David Ekpenyong has done, and I think it's important. I will get into a video of the many lies from John David Ekpenyong that judges did nothing about. Justice Sheard then transferred the case from Hamilton, normally where all divisional hearings are heard, to Kitchener, which I didn't appreciate. Going up to Kitchener. So here I am, the family court thing was started, and I'm going back to Kitchener, which I shouldn't have. And also Justice Sheard, she fined me $200 for being 10 minutes late. Which is ridiculous because John David Ekpenyong, and he requested, I think, for like $400 or $500. Again, abusing the cost process with this judge, with this lawyer. So she fined me $200. I had to pay $200 for being late 10 to 15 minutes because I couldn't get onto the courtroom. Meanwhile, this John David Ekpenyong, I can't tell you how many times he's been late or doesn't show up. So that was frustrating. This judge advised both parties to upload and file materials to case lines no later than March 1st. Sorry, let me back it up. My apologies. February 26, 2024, we get in front of Justice Leanne Standrick. And I'm just going to say, out of all the judges I've dealt with in Kitchener, this judge was the most fairest, truly impartial, and non-biased. And I appreciate this judge for conducting herself this way, because This judge is a truly fair judge, and if anyone gets in front of her, you have a fair chance. She is a fair judge, and I appreciate how she handled the case. So this is where, things start to take a turn, though. So this judge asked both parties to file and upload materials to case lines no later than March 1st, 2024. I followed everything that this justice said to do in her endorsement, and I will share that endorsement. So John David Ekpenyong never filed his materials, and I'll share the case lines portal because this is a common huge inconvenience dealing with this lawyer. Every matter I've dealt with this lawyer, every case, whatever, motion, this lawyer just does not file his materials. And he did it in the Landlord Tenant Board. He did it in the family court. He did it in this divisional court. He's done it in the civil court. And there's rules to be followed. And when it comes to filing the rules, it hasn't been followed. They give him a pass every time. So, this is a significant event that I'm about to talk about. It's on May 24th, 2024. We get in front of Justice Katrina Braid. And a major event happened at this motion. At the motion, Justice Braid had returned from a break to write and read her endorsement. She spoke for about 10 minutes or more. She highlighted how she caught John David Ekpenyong lying and was very concerned about it. And I'm going to read that part of the endorsement, because this is very important. So, Justice Braid said in her endorsement that later went missing. I'm reading this from transcripts I ordered because Justice Braid's endorsement was deleted and altered. And, okay, so this is Justice Braid commenting about John David Ekpenyong's behavior when he got caught lying straight up to this judge, and she was upset with him. I am also concerned about the respondent's counsel. Mr. Ekpenyong, he arrived 15 minutes late, telling me that he couldn't find the Zoom link, which is not acceptable. He was not robed and said he thought it was a small claims court matter today. This indicates that he simply was not properly prepared for this hearing. More concerning is the fact that Mr. Ekpenyong did not answer direct questions from the court and at one point misrepresented a fact. I have great concerns about this conduct. Okay. This lawyer got caught straight red-handed lying. Okay. Multiple times. And, so here I am. I'm getting penalized for being late 10, 15 minutes, $200. This lawyer does the same thing, and it's like it's nothing. This is part of the unfair dealings with these courts. Because I'm self-represented, I'm taking time off of work, I'm preparing materials, getting things commissioned, that printing things, paying for internet. They took no account into these costs that I had to endure with a lawyer who behaves like that. This endorsement was almost originally 8 pages long. Okay? And, about 1 or 2 months later, I requested for a copy of Justice Braid's endorsement. When I received a copy, I noticed right away the endorsement was significantly different and reduced to 1 page. I was blown away about finding this change. Can a judge do that? Is it legally allowed? Is this not considered tampering with a document or even forgery? Is this not considered altering a document? To me, reading the definition of forgery, some of these things come up. And I think it's pretty evident that this case was tainted after this event happened. So if a judge goes behind parties' back and deletes a court document and alters it without notifying anyone, this should be seen as very concerning, which it wasn't. A complaint was filed with the Canadian Judicial Council. This action was brought up to other judges, and nobody did anything about it. This action by Justice Braid was extremely tainted my appeal. This was brought up to the appeal judge, Justice John Krachenko, and I will get into that later in the video, and what he did about that and what he didn't do about that. The motion before Justice Braid was to request to introduce new evidence, and John David Ekpenyong requesting to secure cost. So we on that endorsement, and this is where there's kind of another a twist in it. So I introduced the police reports. There was police reports. So here's the thing. A police report was hidden for 2 years by John David Ekpenyong's client, who admitted to the police, I was a tenant, I was paying rent, I was renting the basement, and she applied for, John David Ekpenyong's client, applied for a eviction application. These two crucial documents were withheld. So this judge, she accepted the materials. What I thought was I missed out the most important police report. So at that hearing with Justice Braid, she accepted the materials, but she didn't accept. I thought I missed the police report. She's like, no further reports are allowed. Moving forward, they twisted it to say that that this judge didn't accept the materials, when in fact she did. The original police reports she accepted, but she said nothing else would be any further new evidence would not be accepted. So the police reports get accepted. We are approaching December 2024, and John David Ekpenyong has still yet to file any materials as directed by Justice Standrick. From her endorsement dated February 26, 2024. So John David Ekpenyong was late filing his original response, and we're approaching December, and he has not filed any materials from that endorsement. So on November 29th, 2024, I schedule a motion to request to have the matter dismissed. We are before Justice Michael Gibson, Kitchener's top judge and local senior judge. The same judge who I went before at the family court trial. The same judge who tarnished my name in his endorsement, entertained a fraudulent bill of costs for $160,000 from John David Ekpenyong, and ordered me to pay $60,000 of court costs that were never worked or money exchanged hands. There was a crucial document at that family court trial. It was an exhibit where John David Ekpenyong admitted to charging his client a block fee of $7,000 and nothing more, where Justice Michael Gibson lost his top. You can hear this in the audio recording of that trial, which he did not want to release to me. But it wasn't until he was in charge of this court cost, I was told by the Waterloo Recordings Department, that I could get a copy of that trial, the audio recordings, free of charge. Which I knew something was going to happen out of that, and it did with the $60,000 court costs. Um, you know, the other thing I wanted to talk about was that endorsement, which I meant to take pictures of and reference. But what I will say off the top is that on Justice Gibson's, and when I say Justice Gibson tarnished my name by his endorsements that are now public, he made statements on those endorsements that can't be backed up by evidence, facts, or exhibits submitted. In fact, it was the opposite. You know, saying that I called the applicant, I emailed her, I was not a tenant, and I breached my temporary restraining order when none of these things happened. Also, too, Justice Gibson gave me, Justice Gibson at that trial asked me if the restraining order, how it could negatively impact my life. Well, I said it could affect my job. Being a electrician, working on various job sites, different cities, the restraining order could impact my job. And, this judge basically had no regard. Obviously, he has no regard when he entertains a fraudulent bill of cost that is fraudulent. $160,000. Let's just stop playing these games, and how about we just ask John David Ekpenyong to show proof of payment? That's all I'm asking. I want proof of payment. You ordered me to pay money. Show me proof that money was paid. Justice Gibson said that John David Ekpenyong's client has reason to believe to fear for her life when there was no ever police history of any issues. There wasn't. The applicant admitted, I never put my hands on her. I never threatened her verbally. I was never abusive. There was no domestic issues. And this judge, Kitchener's top judge, not only put a restraining order against me, he gave me a lifetime ban. A lifetime restraining order against someone that I never had any problems with. Someone I never lived with. I was never married with. I never had children with. I got dragged to that family court on a restraining order application that was never signed. A trial schedule endorsement form was never filled out, served, and filed by the applicant or her lawyer. In fact, Justice Tweedy tried to fill it out, blocked out almost 2 pages of transcripts, and then a trial was scheduled by the trial scheduling coordinator's office, and I'm convinced it was from Salone French, who was very rough and rude and disrespectful to me one day, and so that form was never filed. And if you look at Family Law Rule 17, Sub Rule 11, that is a requirement before any trial is scheduled. And this was brought up to Justice Gibson, and he said that we're here now, we're going to deal with it. So that family court case was very troubling. And that trial judge is now I'm in front of. And I remember that day, John David Ekpenyong wasn't there. The applicant, the respondent was. His client was. And she blurted out, Mr. Dobson, there's a fictitious application against me, which I'm convinced John David Ekpenyong has taken on. He's taken this on personally. Like, I don't even think he's charged his client for that application, which is going to be another video dealing with that. So his client brings it up, and Justice Gibson says, "Oh, I'm very familiar with that case," and he comments on it, and it was kind of unfavoring. And how could Justice Gibson forget about that case when he was the judge who overheard that trial? He overheard the witnesses get caught lying, get caught reading from notepads, admitting the lawyer coached the applicants, the witnesses. And then he ordered me $60,000. How could this judge forget that case? Of course he wouldn't forget that case. So then Justice Gibson instructs John David Ekpenyong to file his materials no later than December 31st, 2024. And you wouldn't believe, well, you might believe with the pattern, but John David Ekpenyong ignorantly emails me on that date, which is New Year's Eve. The filing deadline was 4 p.m. This lawyer emails me at 8:01 on New Year's Eve while I'm out with friends and family trying to enjoy my night. This ignorant and incompetent lawyer emails me past the deadline. Again, doesn't follow Justice Standrick's endorsement. Doesn't follow the original response date. Doesn't follow Justice Gibson's endorsement. And you know what? He didn't even file his materials for the appeal, which I'm going to get into. And this court just allowed this along the whole way. So, John David Ekpenyong, by doing this, is intentionally trying to upset me. And to be honest, what kind of sensible and competent lawyer would even do this? This was a malicious action. You've got 30 days to file your materials. You're going to do it on the day of and late on New Year's Eve. Like, do you not have anything better to do with your life than to do this? No, he doesn't, because he is personally taking this out on me. And there's some theories about that I'll get into in another video about John David Ekpenyong and my personal experience dealing with this lawyer. So I want to get into... So here we go. His materials were late and should not have been accepted by the civil court or the next two judges I went before following this. The court staff accepted his materials late and judges did, which is extremely prejudiced against me. Rule 1603.10 is the rule that was ignored and not abided by, and this rule is deemed service email. Number 10. Where service is made by email under subrule 789 between 4 and midnight, it is deemed to have made on the following day. John David Ekpenyong's materials were not accepted by the court until January 6, 2025. So not only are, it's just not only is this a handicap match with these judges, but it's also with the court staff. So John David Ekpenyong materials were served on New Year's Eve at 8:01 p.m. and accepted by the civil court staff on January 6, 2025. When questioned this, John David Ekpenyong emailed me stating, my internet must have been down. This is what I'm talking about, the ignorance of this lawyer. And I'm going to share that email with you guys, how ignorant this lawyer is. And because he has the impression he can get away with abusing the court process, he can request money that was never paid. He's so foolish to just continue to lead into this type of comment. So when I got Justice Gibson's endorsement, it was I couldn't read it. I couldn't understand 3 words of it, straight up. And I couldn't understand 3 words he wrote in that paper. And if you want my honest opinion, when I looked at that endorsement, it looked like chicken scratch. And one might say it was an intentional to put salt on a huge wound previously received from the judge who managed a family court trial that I was unlawfully dragged into. I could not read that endorsement. I had to get interpretation from a court staff, and I don't even know how they interpreted it. But I think it was like a joke. When I got that endorsement, I couldn't read it. It was it seemed like a joke. Like this judge is having fun screwing with me, considering this the family court case and those endorsements and everything else that transpired from this. Again, I had nothing but respect for all of these judges going into this, and this is how they treated me. On January 27th, so this is another major event here that I want to share with you guys. I think is so important to share with you guys. So on January 27th, 2025, I served John David Ekpenyong with an affidavit and Form 37A, which is a motion. I filled out, served, and filed my affidavit of service. I am given a date for the motion, which was February 13th, 2025 by the trial coordinator's office. On February 7th, 2025, I confirmed my attendance with John David Ekpenyong and the trial coordinator's office. I also file my confirmation of motion, which is a 37B form, with the courts, and it was accepted. February 13th, 2025, I attend the motion. John David Ekpenyong and his client did not show up. Justice Robert Reed, like previous judges, made extremely contradictory statements on his endorsement that are untruthful. Justice Braid states his endorsement matter was in fact, so he says in his endorsement, this is another thing I wanted to reference, but off the top, this endorsement, this judge says that my materials were not filed and I was not confirmed. I did not confirm my attendance when I did. And my materials were uploaded to Caseline. So this judge sat there and said that my materials weren't filed, my confirmation of attendance weren't filed. Mind you, John David Ekpenyong has not done this once. In the 3 years dealing with this judge, with this lawyer, he has not filed one attendance, one appearance. And they roll it out every time. This judge criticized me, saying in his endorsement that this was an issue in the past with filing materials. It was never an issue in the past filing materials. And this upsets me reading this endorsement from Justice Reed, because what he says about me strictly applies to John David Ekpenyong. You know, he hasn't filed any of his materials. He doesn't even show up to a motion, and I get shitted on by a judge, another judge. This was just so unfair and so biased and so prejudiced, and it just upsets me when I think about what happened to me and what I read from these endorsements. So yeah, this another contradictory statement, that can be referenced by other judges, that is untrue. I filed my materials. I confirmed my attendance. I uploaded my materials on Caseline, and this has never been an issue in the past. And this judge says the opposite of all these things. So Justice Reed is criticizing me, but yet does not make any comment how John David Ekpenyong refused to show up to this motion. John David Ekpenyong was served, forms were filed with the court, and nothing was mentioned about this. Talk about gaslighting. Justice Reed adjourns the motion to the appeal hearing and kicks me out of the Zoom like that. Right. Which, luckily, I've had a witness for the last 3 or 4 months to witness a lot of these things happening. And I'm so lucky for that. Again, just to remind everyone, I have nothing to gain to mislead. I'm trying my best to minimize the criticism. But I think in a rational and logical world, it's only obvious someone would be upset when they get dragged through this and these comments are put on documents. So it's just straight up crap what I dealt with. So moving forward. And another judge actually got upset with me and kicked me out too one time when Justice Michael MacArthur, for this another matter, he did not like that I came prepared and what I had to say. Again, I've got nothing but respect for every single judge that I go in front of, and I make sure that regardless of their past or what they do, it's just, so they do that to me. They kick me out of the Zoom because, it was unnecessary. So now we're at the appeal. It's now March 5th, 2025, and we are in person at the Kitchener Courthouse, room 202, in front of Justice John Krachenko. The appeal. It's evident dealing with John David Ekpenyong and his client in the Kitchener Court, it's always been an unfair handicap match. So I was fortunate to have support with me that day. The same person who's also witnessed the abuse I have been dealing with. I came extra prepared. Laptop open, case lines open, notepad open, Wi-Fi logged in. While John David Ekpenyong could not even log into the Wi-Fi that had no password. While John David Ekpenyong held up the court, the judge called for a 20-minute break while an IT technician came up to the courtroom to show John David Ekpenyong how to log into the court's Wi-Fi that had no password. This was the notepad I came with, right? So this is what I read that day. I was trying to read. I got interrupted a few times, referencing rules, referencing my items on case line, make it easy for the judge, try not to waste court time, something John David Ekpenyong is very good at doing. Just look at the facts, order the audio transcripts. It's, again, very mind-boggling how this lawyer conducted himself and what these judges tolerated and turned a blind eye to. Right, so those transcripts, I had them all ready on case lines. To reference for this judge. I presented my appeal. I read the police report that I properly submitted before the court on case lines before Justice Sheard endorsement instructions. A police report that John David Ekpenyong and his client withheld for 2 years. It was actually available for Justice Gibson to review at the family court trial on case lines, a document I believe he refused to read. On that police report, the applicant, who was the author of that report, admitted I was a tenant paying $750 a month rent and applied to the Landlord and Tenant Board for an eviction application, which was done, which is file number LTB-L-014-197-22 was the eviction application that was withheld, a crucial document. I often brought up how unfair and prejudiced it was against me to allow John David Ekpenyong several extensions to file his materials. John David Ekpenyong did not abide by any of the judge's endorsements filing deadlines. John David Ekpenyong did not follow several Rule 16 subsections. John David Ekpenyong did not abide by the rules, and neither did the court staff and judges with respects to filing materials late. It's just prejudice, Because I'm self-represented, you're going to give all these extensions, and no, that's just unfair. Also, I didn't want to upset the judge, but I did bring up a couple times how Justice Braid sneakily went behind our backs and altered an 8-page endorsement down to 1. And that should have been enough to dismiss the appeal, to not even allow it to run. That was, I'm still blown away by it, that this happened and no one's addressing it, especially this Canadian Judicial Council, bringing it to their attention, and which will be another video talking about my experience dealing with the Canadian Judicial Council, and to be honest, how broken and corrupted their complaints screening officers are and department is. So, again, is that not considered forgery? Deleting an 8-page endorsement, altering it to a 1-page, leaving out crucial information that I intended to rely on at the trial that was not available because the judge decided to go behind our backs and delete an endorsement? Is this not tainting the case? There was information from that endorsement that it was now missing. I presented my case. It was a no-brainer. I was a paying tenant who was illegally evicted in an inhumane manner and in harsh conditions at the direction of a lawyer who clearly has rocks in his head, thinking this is okay to do so. And you start to wonder, you bring this up to the tribunal, you bring this up to the Law Society, you bring this up to judges, when this action is not allowed to do. And because, again, I believe because I'm self-represented, they won't address this. So I remember 2 things. So here we go. John David Ekpenyong materials were meritless, were filed late, and were filed 1 year late. I remember 2 things very clear when Justice Konchenko was speaking with John David Ekpenyong. When he was talking about the police report not being valid, he was trying to open up small holes of meaningless theories and false facts to try and justify dismissing my appeal, is what came to my mind. Justice Konchenko, he started talking about these police reports, and they started saying that Justice Braid did not, they misinterpreted Justice Braid's endorsement, saying that she denied those police reports, when that's not what happened. She accepted the police reports that I had originally filed, but I thought I missed out the most important one, which I never did. So if you look at that endorsement, Justice Braid accepted the materials that were filed because they were withheld, but she would not accept any further police reports. And again, this was all on the original endorsement that got deleted, that was altered. So, and no one wants to talk about that. And that is a major event that happened in this appeal. So Justice Konchenko was talking about, he started asking, wait a minute, so you're saying that these police reports shouldn't have been accepted? John David Ekpenyong, they shouldn't have been accepted. Again, lying to the courts. John David Ekpenyong should lose his license. He does not deserve the privilege of conducting himself in these courts. And it's a friggin' disgrace what this lawyer has gotten away with. And these are just facts. And again, I'm trying to be very selective with my words, because this is just crap what I had to deal with. So I thought, and I knew, I killed this appeal. I was so prepared. I filed all my materials on time. But this judge wouldn't let me win. None of them will let me win. Again, so if I win, it will go against Justice Gibson's restraining order endorsement and cost order. They cannot let me in this court, because I will start opening up all these issues with the court. Judges blocking out transcripts, deleting endorsements, providing intentional and misleading statements on endorsements where the evidence and exhibits actually tell a different story, a different tale, a different honest version. Justice Gibson did make mistakes on his endorsements, and to be frank, he blatantly lied on his endorsement. And I've said that before. He put on his endorsement that the applicant has legitimate reasons to fear for her life, when there is zero history. He comments about me peeing on a shed. He starts saying things like, I called her, emailed, things that never happened. He's saying this person can fear for their life because of Mr. Dobson's actions that never happened. We put our trust into these judges, into these courts. They're going to make decisions off of evidence and facts. And I've lost count on my hands on how many times that they did not abide by this rule. On March 10th, Justice John Konchenko released his reserved endorsement. And I remember thinking, did he write the endorsement himself, or did he need to consult with anyone first? This is something Justice Tweedy did too with the garnishment dispute. She needed to reserve her decision. Again, another no-brainer decision. John David Ekpenyong did not file any materials at that garnishment dispute, and I lost that dispute. Another very troubling court proceeding, and unfairly handled. So I read parts about dismissing. I remember. So I opened up the file. This endorsement, and I just scrolled to the bottom, and I seen that this judge dismissed the complaint. And I'm just thinking, yeah, they can't let me in. What I've gone through, what I've documented, this is so much corruption going on in this court that I've dealt with. I've given examples. These are facts. This is not some of these judges abused their role, blocking out transcripts, covering up a potential serious misconduct, deleting endorsement. Like, I've already gone through this, so I don't want to explain myself why I think, exercising freedom of speech with giving examples. It's just, that's what I think about this. So I read parts about dismissing the late filings by John David Ekpenyong, and this judge said it was not prejudiced against me. Clearly it was. When you get not one, but 3 or 4 extensions to file materials, and you're telling me that's not prejudice, it is prejudice. I believe it's prejudice. Because I'll tell you this, in another video I'm going to do, the Court of Appeal, when I appealed the family court decision and cost, I went to the Court of Appeal, and what a disaster that was. The judge sitting in that day, Justice Sheard, she said in her endorsement that John David Ekpenyong and his client did not say it was prejudice for me to file this, but she said it was. So it's kind of contradictory there, but so then judge says Justice Braid did not allow the police reports that were previously filed. To be clear, and this is what Justice Kurchenko said, to be clear, nothing turned on this, nor did the reference reports assist the appellant. Are you kidding me? A police report was the most important document of this whole thing, where they admitted the living arrangements to the police. They admitted I was paying rent. They admitted it was a rental unit. They applied to the Landlord and Tenant Board that for an eviction application. This judge is going to sit there and write in stone saying that was not helpful, when obviously it was. And this is what I'm talking about, these statements on endorsements that are contrary to the truth and the facts. So I'll show points 6, 7, that was 8, and down to 24. Comment about the witnesses. The board member made several credibility findings. So Justice Crenshaw says that he comments about the witnesses and how the board member made several credibility findings. And really, those were just geared towards me. When you've got the 3 witnesses admitting that all my stuff was in the basement during the illegal eviction, the one witness who assisted and admitted all of my belongings were downstairs. I had a full friggin' apartment down there. A bedroom, a bathroom, a kitchen, laundry, separate entrance, my own key. The one witness said that they had found a key. They had found a towel upstairs. They're trying to say I'm cohabitating, and all my property upstairs was a towel. I had never property upstairs in this house. It was never a cohabitating situation. Another witness, an electrician, admitted to installing a second panel for the nanny suite. So later on, you can set up a meter to get second readings. And then the third witness admitting that her girlfriend of 20 years did live in the basement and did rent it. And this judge is going to sit there and say that, or the board member is going to say, he found the witnesses credible. Yeah, they were credible for agreeing to my application that I was a tenant. So here's the appeal, that I went through with this divisional court. You see this pattern from the judges handling the case, allowing these extensions, some turning a blind eye to the filing rules. Like this judge here, Justice Crenshaw, he made reference to one law, how one rule about accepting the late filings and it wasn't prejudice towards me because I got them well in advance. And well, no, the rules say if they're late, then court staff didn't abide by this. You know, showing up for a motion that John David Ekpenyong doesn't show up, then the judge is going to sit there that day and say that I didn't file my materials, I didn't file my confirmation attendance, my materials weren't on case lines when they all were, saying that this has been a pattern of me when it was never a pattern of me. In fact, it was from John David Ekpenyong. I just think this was an absolute waste of my time, energy, and effort, having to run around, fill out these forms, get them commissioned, file them. I remember one time filing with the civil court about this case, DC 23-23-5. The court staff there in the Kitchener tried to tell me, oh, this is with the wrong court. You know, file's DC, Divisional Court. The file on the paper was Divisional Court. You know, they just messed with me at this courthouse. I straight up felt like I took a beating behind closed doors with these proceedings. This court enabled a lawyer to conduct himself unethically. Justice Braid caught him straight up lying again, and then and puts it on the endorsement. Later on, deletes and alters that endorsement, which I'm still trying to get confirmation on the interpretation of those actions, and to me, that seems like forgery. Anybody, deletes and alters a document, which happened, that's forgery. So I don't know, are judges exempt from doing that? Can judges do whatever they want in that respect of deleting and altering documents? I think that was wrong. I think that extremely tainted the case. It was intentional, malicious action. Like, why would a judge do that? Why would a judge feel the need to delete her 8-page endorsement and change it to a 1-page or crunch it or whatever they did? So, this was a no-brainer. I was a tenant. I was illegally evicted. This was well over $15,000. The time off of work, the mental anguish, it just took a toll on me. And my advice to anyone, if you're going to do this Divisional Court appeal, you've heard the process, and it's also available online, all those forms that need to be filed. But with my experience, I wouldn't waste your time. When these things happen to me, and they can happen to you, and they just get swept under the rug, there's no accountability. This court is encouraging people to do these things. They're encouraging that lawyers can get involved and direct their clients to evict people when that's not allowed. You can't do that. And there should be disciplinary actions for lawyers who do that. There should be disciplinary actions for judges who delete endorsements. And there's not. There's no accountability. So I hope this video was helpful to everyone. This was so exhausting preparing this. Again, just want to emphasize that really I have nothing to gain to mislead or bash anybody. This is the truth to the best of my knowledge. And it's horrible what happened to me. I have a cat, my cat Ozzy, who's sitting here. I'm thinking about the 3 animals that died tropical fish, which are still considered animals. How not only inhumane was the illegal eviction for me, but them too, that they ultimately died. What would have happened to my cat? Would he have been stolen? Would he also been left in the cold in a cage? Like, I was trying to move out of this apartment. The cat was already in Burlington. All my stuff was packed up. And then all these things happened. There is so much questionable conduct from this lawyer and these judges and the court staff and the applicant withholding a police report, withholding an eviction application. And these judges do nothing about it. This is sending the wrong message and almost encouraging people that they can do these things without any accountability. So that's my experience with the Divisional Court that ultimately ended up in the Kitchener Superior Court. Still shocked about everything that happened. And in my opinion, the courts are just broken. There's corruption. There is, we put our trust in these courts. We pay these courts, these public servants, us hardworking Canadians who work our butts off and have to fork over most of the time half of our paycheck are paying for these judges, are paying for these court staff, and this is how they're handling it. They're abusing and misusing the money. When these things happen, there should be some serious concern. And there's not. So, I'll leave it at that. Thank you guys so much for watching. For those that watched this whole video, just thank you guys for listening. If you guys have any questions about the process, the filings, you can get everything online. I've got a little bit of experience, obviously, dealing with all this, what you can expect. But again, I would avoid the Divisional Court and appealing. It's costly, and when there's supposed to be rules that are abided by, that are not abided by, when you give a lawyer 4 extensions and allow them to file materials, not 1 month, not 2 months, but 1 year late, that should be extremely concerning, and it wasn't. And just for that reason alone, I would avoid the Divisional Court. And so, thank you guys for watching. This has been another video on Let's Talk About It, and this is my experience with the Divisional Court. So thank you guys for watching.